Okay, good morning, ladies and gentlemen. Welcome to this briefing by the ACT Electoral Commission on the new legislation regarding campaign finance and reporting. And I'd like to firstly acknowledge the honourable people as original custodians of the land on which we are briefing and having our discussions this morning, and acknowledge the contribution that they make to this great city and region. Now, my name is Damien Cantwell. I am the Electoral Commissioner, and I understand a number of people have logged in. There'll be probably others joining us as we speak. I expect this presentation and the questions will go no longer than about an hour. I appreciate you dialing in and your interest in this important matter. Effectively, what I'd like to do is first introduce the topic and then hand to my Deputy Rose Spence, who will speak to the detail. But firstly, the purpose of this briefing is to brief you on the new legislation which is coming to effect in the ACT from 1st of July with respect to the prohibition on political donations by property developers, their close associates, or those acting on their behalf, and also the obligations that extend to the acceptance of such gifts by the political entities. It's important that we give this brief at this point in time so that you've got an opportunity to understand what the legislation changes mean, how they impact upon both political entities, but also the property developers, close associates and their representatives, both in terms of their actions and their obligations. I stress though up front though that this is not a legal briefing in that regard. I'd encourage any entity or any stakeholder impacted by these legislative amendments to seek their own legal advice and their own analysis of what their obligations are. The Elections ACT office is always available to engage with you, to help you understand and enact your obligations under this new legislation, and to, as best able, answer your questions, both through to the commencement date of 1st of July, but of course beyond that date. And the details of our points of contact are available on our website, and you can contact the office at any time and the staff will be very happy to help you out. The purpose of this briefing, as I said, is to give you an understanding of what your obligations are, and as we have understand them, the legislative enactment of such, but also to give you an opportunity to ask questions, and there's a couple of means by which you can do that during this session or later. The purpose of the changes, though, themselves that have been now in place but will be enacted from 1st July are to enhance the disclosure provisions effectively and to prevent the possibility of undue influence of those stakeholders affected by this from the political process in the ACT. It's an important piece of legislation and I want to make sure that all of us have an understanding of it, but also to avoid inadvertent breaches of the legislation, particularly in its enactment in the early days, and to make sure that everyone who's affected by this understand what their obligations may be. I'll also highlight that there are other legislative amendments in place to take effect from 1st July. I'm happy to talk to those if needed for this presentation, but really focusing on those issues around donations by or political donations by property developers to ACT political entities. Again, I'll refer you to the website for further information, or indeed any questions you'd like to ask during this presentation, please feel free to do so. I'll hand over to my Deputy Rose Spence, who will talk through the detail of the changes to the legislation. It's quite complex, as Roy will highlight, but we'll step through it in good order. And I'd ask for you to, again, think carefully about it and ask questions as you may wish. Thanks very much. Roy, thank you.
Good morning, everyone, and thank you, Damien. As Damien did mention earlier, the ACT Electoral Commission does not provide legal advice, and we recommend that participants obtain their own legal advice about the interpretation of the laws and their individual circumstances. Each electoral participant is responsible for complying with the electoral laws and their particular circumstances and how they intertwine. Today's briefing is based on the Electoral Act in the ACT, and there will also be some discussion on the Commonwealth Electoral Act and how that has an impact upon the ACT's funding and disclosure scheme. So the ACT's funding and disclosure scheme has been in place in the ACT since the ACT was granted self-government in 1989. Funding and disclosure legislation is very much the most dynamic element of electoral law in the ACT and has been introduced and repealed regularly throughout the life of the Assembly. But the general concepts and objectives for a funding and disclosure scheme remain relatively constant. The objectives of a funding and disclosure scheme is to facilitate the conduct of free and fair elections and maintain voters' confidence in democracy. And it does this by enabling parties and candidates to present their policies to the electorate through the provision of public funding, preventing corruption and undue influence by reducing a reliance on private funding through the provision of public funding, preventing corruption and undue influence through disclosure of the sources of private funding, and providing transparency in the finances of political participants to inform the electorate of the sources of political funding. The ACT's funding and disclosure scheme was amended again in August 2020 to give effect to a number of legislation changes. These amendments formally take effect on the 1st of July this year and have had the effect of changing the reporting schedule for the disclosure of gifts, altering the definition of a gift by including all fundraising contributions, prohibiting the giving of political donations by property developers and on the receipt of such gifts by ACT political entities, and establishing misleading electoral advertising laws, better known as truth in political advertising. I'm going to be talking today about the impact of the Commonwealth Electoral Act upon the ACT's funding and disclosure scheme following recent federal amendments also. Up front, I do apologise for the complexity of some of the content today. It's pretty dense, but the laws are fairly complicated and we do need to brief you appropriately. Because a number of you here today will only have an interest in the impact on the donations, the ban on donations from property developers, we'll start with a discussion of these new laws and then we'll stop for questions from the participants. Following this, anyone whose interest does not extend into the further Electoral Act amendments is of course free to go. So without further ado, we'll move on to property developers. So in a nutshell, from the 1st of July 2021, a property developer, a close associate of a property developer, or a person acting on behalf of a property developer or their close associate will be prohibited from giving a gift of any value to a political entity in the ACT. For the remainder of this briefing, I'll refer to this grouping as prohibited donors. So a property developer, a close associate of a property developer, or someone acting on behalf of a property developer or a close associate is known as a prohibited donor. So a prohibited donor cannot donate to an ACT political entity, and those same political entities are also banned from accepting a gift from a prohibited donor. And it's important to understand that there is no relevant cap on donation amount. The ban is on gifts of any value. However, the penalties for a breach do vary dependent on the value of the gift provided. So where a gift is given or received and the value is less than $250, the giver and the receiver must pay to the territory an amount equal to the amount of the gift. Where the gift has a value of $250 or more, a criminal offence is committed. The penalty for which is a maximum of 50 penalty units, which in current penalty units is equal to $8,000 for an individual or $4,500 for a corporation, or 6 months imprisonment, or both. So of course, much of this depends on the legislated definition of what property developer means and what is meant by the term close associate of a property developer. And of course, the definitions are fairly detailed and specific. I'm not going to spend too much time going over these particular definitions, other than to let you read the exact definitions from the legislation that appear on the screen now. And these definitions are also included in the fact sheet that we have developed for the ban on donations from property developers, which will be provided to you all and published on our website. So this on the screen now is the definition of property developer, and I'll just give you a few more seconds to scan that. And this is the definition in the legislation for a close associate of a property developer. And I'll just give you a few moments also, and then we'll move on, noting that they are in the fact sheet that will be distributed. So whilst we have those definitions for what constitutes a property developer, the requirement for a breach of the law by a political entity is also dependent upon the time in which the gift is given in relation to the activities, past or present, of the property developer. So if a political entity accepts a gift from a prohibited donor, and at the time that that gift is given, the prohibited donor has made one or more relevant planning applications that are yet to be decided, or in the 7-year period prior to the gift, the prohibited donor has made 3 or more relevant planning applications, and the political entity has not taken reasonable steps to ensure that the person is not a prohibited donor that has 1 or more planning applications yet to be decided, or 3 planning applications in the past 7 years, then the political entity will be subject to a penalty as described previously. So what this really means is that political entities are required to take reasonable steps when accepting donations of any value in order to ensure that they're meeting the intent of the Act and are also protecting themselves from committing a potentially criminal act. The Act does provide some guidance on what may be considered reasonable steps, and they can be dependent upon the value of the gift received. The legislation provides that where the value of the gift is less than $250, reasonable steps may be giving potential donors written notice that donations from property developers or close associates of property developers are prohibited, or asking the person who is giving the gift whether the person or persons associated with the gift are property developers or close associates of a property developer. Where the value of the gift is $250 or more, reasonable steps might be obtaining a written declaration from the person who gives the gift declaring that the gift is not from a prohibited donor under the law, asking the person who gives the gift whether the person is a property developer or close associate of a property developer, or for a fundraising event intended to collect gifts from a large number of potential donors, providing clear written notice to potential donors that property developers and close associates of property developers are prohibited from giving gifts to a political entity. Elections ACT has developed some suggested forms and wording to assist political entities in this particular process. It's appended to the fact sheet on property developers, and we'll circulate those to assist parties following this briefing. While the ban on property developers, as we've just discussed, fully takes effect from the 1st of July, there has been a transitional period in place since the day after the most recent ACT election. So from the 18th of October 2020 through to the 30th of June 2021, it was still prohibited to provide and accept property developer donations. However, the penalties that applied to a breach of this law were quite different for this period. So if during this transitional period, a gift from a prohibited donor was accepted by a political entity and was not returned to the prohibited donor within 30 days of the receipt of the gift, the political entity must pay an amount equal to the value of the gift to the territory. Now, the Act provides for the ability of a person to apply to the Electoral Commission on behalf of a corporation for a formal declaration declaring that that corporation is not a property developer. The Electoral Commission can only make this declaration based solely on the information provided by the applicant as part of the application process. The Electoral Commission may make its declaration if satisfied that it is more likely than not that the corporation is not a property developer. However, if the Commission, upon assessing the application, is not satisfied and rejects the application, this is not in and of itself a declaration that the corporation is, in fact, a property developer. A decision not to declare is not recognition of a corporation as a property developer. It's simply that the Commission is not satisfied from the information it has on hand within the application that it's enough to satisfy the conditions for a declaration. Once a declaration is made, it is conclusively presumed to be correct for the purpose of making or accepting a gift during the period the declaration is in force, even if that declaration is subsequently found to be incorrect. But it is not presumed to be correct in favour of a person who makes or accepts a gift, knowing that the information on which the declaration was based was false or misleading. Declarations, if made, are in force for a period of 12 months and will be published both on the ACT Government Legislation Register as a notifiable instrument and on a register on the ACT Elections ACT website. So we're now going to move on to the impact of relatively recent amendments to the Commonwealth Electoral Act that commenced on the 1st of December last year. Participants today may remember, going back to around 2019, amendments made to the Commonwealth at the Commonwealth level that essentially meant that the ACT disclosure laws did not apply in a material way for a period of time. Well, the federal government has adjusted those laws and new amendments now apply. These amendments continue to have an effect of limiting the operation of the ACT's funding and disclosure scheme, but just in a different way. Now, the impact of these amendments is now fairly specific and is really in relation to political parties that have got registration in the ACT for the Assembly elections and also are registered federally with the Australian Electoral Commission for federal elections. For the purpose of this briefing, we'll call these parties parties with dual registration. The Commonwealth legislation also applies to associated entities of those same duly registered parties. The impact of the Commonwealth laws mean that for gifts provided to a party with dual registration or its associated entity, and the laws the gifts have been deposited immediately into a federal election account, the receiver of the gift is not required under territory law to disclose the gift to the ACT Electoral Commission. Depending on the size of the gift, the entity may still have federal disclosure obligations, but we don't have it. But we, as the ACT Electoral Commission, don't have administrative oversight of that. So I'm not going to be going into that today. So to summarise that law, for a gift not to be disclosable under territory law, a party with dual registration or their associated entity must deposit it into a separate and specific federal election account as soon as reasonably practicable. That money can then not be used for a territory electoral purpose ever. Now, these amendments also have application in relation to the prohibited donor legislation. The prohibited donor legislation does not apply if the prohibited donor expressly gives the donation to the political party that has dual registration for a federal purpose. So to summarise, a prohibited donor may provide a donation to a political party that has dual registration if, when giving the gift, they expressly state that it is for federal electoral purposes. And similarly, for a political party with dual registration or their associated entity, the prohibited donor legislation does not apply if, when receiving a gift from a prohibited donor, they deposit that gift into a specifically designated federal election account, or if the gift is not money, keep the gift for federal purposes and use it only for federal purposes. It is, however, important that ACT political parties and associated entities continue to comply with ACT disclosure scheme, where they keep or identify a gift separately in order for it to be used only for territory electoral purposes, or the gift has been donated with the express designation that it has been used for territory electoral purposes, or no designation was made when the gift was donated and it has not been deposited into a federal election account or kept separately for federal purposes. A word of warning, however. The Commonwealth Electoral Act explicitly states that should any funds that have been deposited into a federal election account be used for any purpose other than a federal electoral purpose, or to be transferred out of that federal election account into a different account, then the entire account ceases to function as a federal election account, and all funds within it become exposed to the application of territory electoral law. So that means that any funds within that account that have not been disclosed to the ACT Electoral Commission within the designated disclosure period under ACT law will immediately be in breach of ACT law. It also means that if funds within the account have been provided to the entity by a prohibited donor, an immediate breach of the prohibited donor laws will have been committed. This could expose not only the political entity that accepted the gift to criminal prosecution, but also the prohibited donor. How a political entity administers the funds within its federal election account is therefore vitally important. Great care should be taken when moving money out of that account. So compliance audits. Anyone familiar with the ACT's campaign finance regulations will know that the Electoral Commission is empowered to issue investigation notices to examine the financial records of any political entity. Currently, the Commission conducts compliance reviews of various political entities in relation to gift disclosures, the use of administration funding payments, and electoral expenditure as part of an election campaign. However, with new legislation, the Commission is now required to administer and enforce campaign finance with respect to the ban on donations from property developers. This will require investigative processes into where donations have originated and whether the provider of the gift is in fact a property developer, a close associate of a property developer, or someone acting on behalf of a property developer. And unlike the current gift disclosure threshold, the reviews will not be limited to gifts of $1,000 or more, but can and will look into gifts of any value. The Commission will be approaching the new compliance reviews as a separate process to the current compliance program. The current program will remain unchanged, seeking to ensure that disclosed details are consistent with the financial records of the entity. Whereas the additional compliance and enforcement program will now be required to investigate whether the gifts received originate from one of the entities listed as a prohibited donor. This may require reviews into family ties, organisational structures, associated corporations and shell company arrangements. This could also mean that compliance reviews may now be more regular and could also involve the issuing of investigation notices under the Act to anyone the Commissioner has reasonable grounds for believing can produce a document or give evidence about anyone's compliance with this new law. Now, we'll take a little break from the presentation here so that any questions in relation to the ban on property developer donations that have been asked can now be answered. And feel free to continue to type any questions in as we address the ones that are already lodged, if there have been any. And following this question section, we'll move on to topics that are only relevant to political parties and other political entities. So any attendees just here for the discussion around prohibited donors can leave knowing we've covered that topic. No questions? No. Okay, so we'll move on, but feel free if anything does occur to you to continue to ask it, and we'll stop a couple more times for questions, and we can always address any property developer ones at that time. Okay, so the new laws that came into effect from 1 July have also had the effect of altering the disclosure schedule in relation to gifts received of $1,000 or more. A gift must still be submitted to Elections ACT when a gift or sum of gifts totaling $1,000 or more is received from the same organisation or individual in a financial year. That bit has not changed. However, the timing of the gift return has now been altered. During the election period, which commences 36 days before polling day and until 30 days after the election is declared, this period is known as the defined period. If the value of a gift or gifts received during this defined period reaches $1,000 for a financial year, a disclosure return must be made to the Commissioner within 7 days of the total amount received from that person or organisation reaching $1,000 threshold. If during this defined period any additional gift is received from the same person of any value, a further disclosure must be made within 7 days of its receipt. Outside of this defined period, so any time outside of the election period and the period 30 days after the election is declared, then a gift return must be submitted within 7 days of the end of the month in which the total amount received from a person or organisation reached $1,000. Again, any additional gift received from the same person or organisation of any value must be disclosed within 7 days of the end of the month in which it was received. So it's important to understand that the reporting of gifts is no longer staged in increments of $1,000. Once the $1,000 threshold is reached, all gifts received from that same donor must be reported in line with the disclosure schedule in place at that time. As way of an example, if a party was to receive a gift of $1,500 from a person on the 27th day of August, the party would be required to disclose the details of that gift by the 7th of September. That is 7 days after the end of the month. If that same person was then to attend a fundraising event in October and purchased a raffle ticket to the value of $10, the party would be required to disclose the details of the $10 interaction by the 7th of November. Again, 7 days after the end of the month in which the final financial interaction took place. Once the disclosures are made to the Electoral Commission, they will be made public on the Elections ACT website as soon as possible after the disclosure has been made. From 1 July, the manner in which the Act deals with fundraising contributions will also change. The new amendments have removed the definition for fundraising contribution and fundraising event, meaning that the definition of what is a gift has been altered. Previously, the part of a fundraising contribution that was less than $250 was not considered a gift. This is no longer the case. But to understand the effect of this change, it's necessary to understand what is meant by a gift. Broadly under the Act, a gift is the disposition of property, including an amount of money, made to someone without adequate consideration, or the provision of a service other than volunteer labour for no consideration or inadequate consideration. So essentially giving something without receiving something in return, or in relation to the provision of a service, providing a service without receiving something of equal value in return. The new laws mean that fundraising contributions of any value are now considered a gift, and when a gift or collection of gifts reaches the $1,000 threshold, disclosure obligations are triggered. So from 1 July, fundraising contributions made by a person or organisation, including entry fees for a fundraising event or items purchased at an auction, are considered a gift to the beneficiary of the fundraising event. However, the amount of the gift is the amount in excess of the consideration received in return for the fundraising contribution. And this is where it gets complicated. For example, if a person was to purchase a ticket to a fundraising event at a cost of $200, the value of the gift from that person is the $200 less the consideration they received at the fundraising event. As a simple example, $200 less the value of the meal provided at the event, valued at, let's say, $70. So the gift value would be $130. As another example, a person purchases an item at a fundraising auction. The person pays $2,000, but the market value of the gift is $1,500. The person has received consideration for their fundraising contribution to the value of that $1,500, so the gift amount is $500. We'll pause again to address any questions lodged in relation to the amendments just discussed before we move on to the new truth in political advertising laws. Still no questions? We'll pause one more time for questions, so feel free to type away in the chat function. Must mean this is being, it must be crystal clear. Okay, so moving on to misleading electoral advertising law, or what many people refer to as truth in political advertising. The Electoral Amendment Act also established a new offence within the Electoral Act. So from 1 July 2021, a person now commits an offence if the person disseminates or authorises the dissemination of an advertisement containing electoral matter, and the advertisement contains a statement purporting to be a statement of fact that is inaccurate and misleading to a material extent. The maximum penalty for committing this offence has been set at 50 penalty units. Currently, that's the equivalent of $8,000. When the Commission receives a misleading electoral advertising complaint, it will commence a formal assessment process against specific criteria. To substantiate a misleading electoral advertising complaint, the advertisement must contain electoral matter, which is a defined term under the Electoral Act, and it must contain a statement purporting to be fact. That is, the Electoral Commission cannot apply misleading electoral advertising law against statements of opinion, and the relevant statement must be inaccurate or misleading to a material extent. To commence a formal assessment process, the Commission will require a complaint to identify the element of the advertisement that is being disputed as inaccurate or misleading, and will require detailed evidence in support of this claim. The complaint should provide sufficient information on which the Commissioner may form a view. The Commissioner may then undertake investigations in order to corroborate the supporting evidence supplied. For example, it may be necessary for the Commissioner to seek further information from either or both of the complainant and the alleged offender. It may also be necessary for the Commissioner to seek external advice to enable the Commissioner to form a view on whether or not the advertisement is misleading or untrue. It is important to note that to ensure due process, this process may take some time, including during and through an election period. So what happens after the Commissioner completes the assessment? Well, if after completing the formal assessment, the Commissioner does not find that the electoral advertising contains a statement that is inaccurate or misleading to a material extent, the Commissioner will write to both the complainant and the author of the electoral advertising, advising of the outcome, and no further action will be taken in relation to the complaint. But if the Electoral Commissioner does identify a breach of the law, remedial action by the person responsible for the advertising will be required. This could take the form of three possible actions, which can be used by the Commissioner in combination or in isolation. The Commissioner may formally write to the person asking them not to disseminate the advertisement again, and or publish a retraction in stated terms and in a stated way. So, for instance, if a person publishes the misleading advertisement in a newspaper, the Commissioner may request a retraction be published in that same newspaper. It is also at the Commissioner's discretion to apply directly to the Supreme Court for an order obliging the person to cease disseminating the advertisement and or publish a retraction. And if the person is found guilty by the court must take the person's response to any earlier request by the Electoral Commissioner for remedial action into account when applying a penalty for the offence. And finally, the Commissioner also has the discretion to refer the matter to the Director of Public Prosecutions for possible criminal prosecution. So that wraps up the content of this briefing. We can now address any questions that you may have. There may still be none. There are still none. So unless someone, oh no, hang on. Is it acceptable to report the full amount? Can we just clarify what that means, the full amount? Yeah, sorry, I'm unsure what that question is in relation to. You just elaborate. If there's any other questions, or if anyone has any questions later on, you are more than welcome to contact the Electoral Commission either via phone on 6205 0342 or at electionsdisclosure@act.gov.au. And there'll also be, there is also now information available on our website, including fact sheets and FAQs on the various topics that we've discussed, and we'll be publishing more as we reach the 1st of July kickoff period for this legislation. But that is the end of our briefing. So thank you for joining us. And like I said, anyone has any questions, feel free to get in contact with us at any time. Thank you very much.